How many people work for the National Cryptocurrency Enforcement Team in the criminal division today?
Can I answer the question about Penn?
I've asked you a question. How many
You've
people
asked
work?
me a question, but you don't
How
want
many
the
people
answer.
work
I'm not
for the
gonna answer your
National
questions the way you
Cryptocurrency
want.
Enforcement Team? You won't answer how many
I'll
people?
answer Penn.
You.
Penn will not be
you know what?
weaponized.
You know what?
What's
Madam
funny
Attorney
about
General,
this?
I'll say to the chairman.
What's funny about
Chairman,
this?
you know what the answer is? And I think I
What's
understand
funny
why the
about
Attorney General
this?
does not want to answer the question. Because you eliminated the National Cryptocurrency Enforcement Team last year. So I understand why you don't want to tell the American people who works there.
Yeah, I
no one
understand
works
why
there
you don't want to
anymore,
talk about
Madam
Mohammed
Attorney
Solomon
General.
in
So,
your district.
In any event,
who
I would
murdered people.
Mr. Chairman, will you stop the clock so his time is not wasted by the witness?
20 minutes before the oversight hearing shifted from routine questioning into a direct examination of credibility, Attorney General Pam Bondi published a statement that was meant to project strength without ambiguity. If you come for law enforcement, the Trump administration will come for you. The wording was sharp, absolute, and intentionally combative. It suggested that the defense of police officers was unconditional and that retaliation against those who targeted them would be swift and unwavering. It was framed as a declaration of principle, not a political slogan. Within the hour, that declaration would be tested under oath. Inside the House Judiciary Committee chamber, Congressman Joe Neguse prepared to examine whether the posture expressed online aligned with the operational decisions made inside the Department of Justice. Neguse's reputation is not built on theatrics or volume. It is grounded in discipline and method. Trained as a constitutional lawyer and experienced in high-stakes proceedings, he approaches oversight as a structured exercise in evidence and logic. On February 11, 2026, he approached the microphone with a sequence designed to expose contradiction through documentation rather than rhetoric. The hearing had already extended for hours. Members had questioned Bondi about the handling of the Epstein files, about redactions that appeared to reveal victims while concealing powerful figures, and about accusations that prosecutorial authority had been applied unevenly. She had responded by reframing inquiries, contesting premises, and defending the administration's broader narrative of reform. The exchanges had been sharp but predictable. Neguse altered that rhythm by returning to her own public statement. Attorney General Bondi, he began evenly, you posted online, if you come for law enforcement, the Trump administration will come for you. He did not editorialize or interpret the statement. I'd like to show you a brief video, he continued, noting that it would run approximately 30 seconds. After that, I have a couple of questions. The request was procedural, not dramatic. The screens in the chamber illuminated with body camera footage recorded on January 6, 2021. The images were unstable and urgent, capturing officers positioned against a surging crowd. A man's voice rose above the commotion, accusatory and contemptuous. You can't see it because you're chasing your pension, right? Your retirement. That's what runs your life. The tone conveyed hostility, delivered amid a violent breach of federal security. When the clip ended, the room returned to its institutional stillness. Neguse allowed a brief pause before posing his question. Attorney General Bondi, that man works for you now, correct? The inquiry was direct and narrowly framed. There was no commentary attached to it. Bondi asked for clarification. Who was that, Congressman? Neguse supplied the name without hesitation. The individual captured in that footage is Jared Weiss. He then identified the relevant fact, that Weiss was employed by the Department of Justice. Bondi acknowledged the employment. He does work for us, she confirmed. Neguse restated the point to ensure precision. He is currently employed by the Department of Justice. Yes, she replied. Neguse then introduced the contextual record. Jared Weiss had been indicted by a federal grand jury on 2 felony counts and 4 misdemeanor counts connected to his participation in the events of January 6th. Among those charges was the allegation that he forcibly assaulted, resisted, opposed, impeded, intimidated, and interfered with law enforcement officers with intent to commit another felony. The indictment was not speculative. It was a matter of federal court record. The charge language reflected serious allegations involving interference with police during a national crisis. Neguse articulated the point without raising his voice. This is an individual who was indicted for interfering with police officers during January 6th, he stated, and he now works at the Department of Justice under your leadership. The juxtaposition was deliberate. The hearing room absorbed the implication in silence. Bondi responded by referencing executive authority. I believe he was pardoned by President Trump, she said. Neguse acknowledged the pardon without contesting its existence. Yes, he was pardoned, he replied. The legal effect of that pardon was not the subject of dispute. What remained was the question of institutional judgment. A pardon eliminates criminal liability, but it does not compel federal employment. Neguse framed his follow-up accordingly. He was pardoned for conduct involving law enforcement officers, he observed. How does that align with your public commitment that anyone who comes for law enforcement will face consequences? The exchange crystallized a tension between rhetoric and administration. Bondi's public statement conveyed an uncompromising stance in defense of police officers. Yet the Department of Justice, under her direction, had hired an individual indicted for interfering with officers during one of the most consequential security breaches in modern American history. The pardon addressed the legal consequences of the indictment. It did not resolve the symbolic implications of the hiring decision. Oversight hearings exist to examine precisely that distinction. Neguse did not accuse Bondi of criminal misconduct. He did not question the president's constitutional authority to grant pardons. Instead, he focused on consistency. If the administration's standard is that those who target law enforcement invite institutional response, then the employment of a pardoned January 6th defendant requires explanation beyond a citation to executive clemency. Bondi did not provide additional context for the decision. Her reliance on the pardon as a sufficient justification left the broader question unanswered. The video had established the conduct captured on camera. The indictment had established formal charges. The employment had established institutional endorsement. Each element stood independently verifiable. Together, they formed a sequence that raised doubts about coherence between declared principle and operational choice. Neguse's approach did not depend on emotional intensity. He constructed the contradiction through chronology. First, the public declaration of protection for law enforcement. Second, the documented conduct during January 6th. Third, the presidential pardon. Fourth, the hiring at the Department of Justice. The structure required reconciliation. Bondi's acknowledgement under oath ensured that the facts entered the congressional record without ambiguity. The hearing's tone shifted from partisan sparring to institutional evaluation. Congressional oversight does not hinge solely on legality. It also addresses propriety and institutional credibility. A Department of Justice that presents itself as an uncompromising defender of police officers must consider how its employment decisions reflect that posture. The question was not whether a pardon is constitutional. It was whether hiring a pardoned individual charged with interfering with police reinforces or undermines the administration's stated commitment. Neguse allowed that question to stand. The hearing room remained composed, but the implications were substantial. When a slogan encounters documentation, the latter carries weight that rhetoric alone cannot offset. Bondi's statement had drawn a bright line. Neguse's questioning examined whether that line held when confronted with specific administrative action. The first phase of the hearing thus established a theme that would carry forward. Accountability requires more than declarations. The questioning did not end with Jared Weiss. For Neguse, that exchange served as an entry point into a more consequential examination of whether the Department of Justice under Pam Bondi still retained the structural capacity to police corruption at the highest levels of government. A single hiring decision could be defended as discretionary judgment, but the architecture of enforcement reveals priorities in a way rhetoric never can. So he moved methodically from personnel to infrastructure. That transition altered the scale of the conversation. Attorney General Bondi, he said, maintaining the same measured cadence. Are you familiar with the Public Integrity section of the Criminal Division, commonly referred to as PN? The question was not adversarial. It was foundational. The Public Integrity section occupies a distinctive role within the Department of Justice, created in the aftermath of Watergate to investigate corruption by elected officials and senior government employees. Its existence represents a deliberate response to a period when executive misconduct exposed the fragility of internal checks. Bondi acknowledged awareness of the office. Neguse followed with a historical inquiry that appeared simple on its surface. Which presidential administration created the Public Integrity section? The question tested institutional literacy rather than political allegiance. Instead of naming President Gerald Ford, who established the unit in response to the lessons of Watergate, Bondi redirected the exchange toward her broader theme of ending prior weaponization. Her pivot reframed the discussion as partisan correction rather than institutional origin. Neguse reclaimed his time to refocus the inquiry. When Bondi suggested that he could not reclaim his time merely because she declined to answer to his satisfaction, the procedural tension briefly surfaced. The chairman clarified that the time belonged to the member recognized to speak, restoring the hearing's structure. Neguse then supplied the historical fact himself, anchoring the record. The Public Integrity section was created under President Ford to ensure that public officials could be investigated independently after Watergate. That context mattered because it illuminated the office's purpose. PIN was not designed as a political instrument, but as a safeguard against concentrated executive power. Its mission involves prosecuting bribery, fraud, abuse of office, and other crimes that erode public trust in government. Neguse then shifted from origin to present condition. When you assumed office, he stated, there were 35 attorneys assigned to that section. He paused briefly before delivering the current figure. There are now 2. The reduction required no embellishment. An office built to investigate public corruption across the federal government had seen its staffing decline by 94% under Bondi's tenure. The scale of contraction was arithmetic, not rhetorical. Bondi did not dispute the numbers. She reiterated her broader claims that the department had corrected excesses and restored fairness after what she described as politicized enforcement. Yet she did not offer a detailed explanation for how 2 attorneys could fulfill the mandate previously carried out by 35. Public corruption cases often involve complex financial trails, coordination with inspectors general, and extensive evidentiary review. They demand sustained attention and specialized expertise. Neguse's point did not rely on accusation, it relied on capacity. When staffing decreases at that magnitude, investigative throughput necessarily declines. 2 attorneys cannot process the same volume of cases, supervise nationwide inquiries, or maintain the same deterrent presence as a fully staffed section. Institutional strength depends not only on statutory authority, but on the resources allocated to enforce it. Without personnel, mandates remain aspirational. The significance of PIN extends beyond symbolic reassurance. Its attorneys coordinate sensitive investigations that involve members of Congress, executive officials, and high-ranking public servants. After Watergate, the country determined that such investigations should not depend solely on dispersed U.S. attorneys' offices. A centralized unit was required to preserve consistency and independence. Reducing that centralized expertise alters the operational landscape. Neguse framed the staffing contraction as a structural fact that demanded explanation. Bondi defended her tenure as one focused on correcting imbalance and preventing misuse of prosecutorial authority. Neguse did not contest her characterization of past controversies. Instead, he highlighted the tangible outcome of reform taken to its extreme. An effort to prevent politicization must still preserve enforcement capability. Otherwise, the pendulum swings from correction to contraction. Oversight is not an abstract exercise. It examines whether executive agencies retain the tools necessary to carry out their responsibilities. When Congress asks how many attorneys remain assigned to investigate public corruption, it is assessing whether accountability remains viable in practice. The reduction from 35 to 2 altered the practical meaning of the Public Integrity Section's mandate. Deterrence weakens when enforcement capacity diminishes. Neguse did not characterize the staffing reduction as criminal or unlawful. He characterized it as consequential. An office created in response to one of the most significant abuses of executive authority in American history now operated with minimal staff. The historical parallel was implicit rather than explicit. Watergate prompted expansion of oversight. The present numbers reflected contraction. The hearing's atmosphere remained disciplined, yet the implications carried weight. The Department of Justice commands immense power, including the authority to indict and prosecute federal officials. That authority draws legitimacy from the perception that it will be exercised impartially and consistently. When the specialized unit charged with investigating corruption shrinks dramatically, questions arise about how vigorously misconduct will be pursued. Numbers alone cannot tell the entire story, but they establish boundaries of possibility. Bondi did not outline a comprehensive restructuring plan in which PIN's functions had been reassigned with equivalent staffing elsewhere. She did not present evidence that investigative capacity had been preserved through alternative channels. The committee was left with the stark comparison between prior staffing levels and current reality. Neguse's method ensured that the reduction was not lost in abstraction. He framed it as a measurable shift in enforcement infrastructure. Public corruption investigations are labor-intensive. They require subpoenas, forensic accounting, witness interviews, and meticulous legal analysis. A skeletal staff constrains the ability to pursue such cases concurrently or with sustained intensity. The cumulative effect is a narrowing of oversight reach. Neguse allowed that implication to stand without dramatization. By this point in the hearing, a pattern had begun to emerge. The hiring of a pardoned January 6th defendant raised questions about consistency in defending law enforcement. The contraction of the Public Integrity Section raised questions about the department's willingness to scrutinize misconduct within government ranks. Both issues intersected at a broader theme: whether accountability mechanisms were being preserved or diminished. Neguse's questioning linked personnel decisions to structural change. The Public Integrity Section symbolizes a promise embedded in federal governance, that those entrusted with power are subject to investigation if they abuse it. Reducing that section to 2 attorneys does not eliminate the promise on paper, but it reshapes its enforceability in practice. Bondi's emphasis on correcting past weaponization did not address the operational challenge posed by diminished staffing. Institutional credibility rests not only on stated principles, but on demonstrable capacity. The arithmetic left little room for ambiguity. As Neguse concluded this portion of his inquiry, he did not resort to declarative condemnation. He relied on the record he had established. 35 attorneys at the start of Bondi's tenure. 2 attorneys at present. An office created in the shadow of Watergate operating at a fraction of its former strength. The contrast underscored the stakes of the hearing. Accountability is not self-executing. It depends on institutional design and resource allocation. When those resources are reduced dramatically, oversight contracts accordingly. Neguse had moved the conversation from a single hiring decision to the structural integrity of the department's anti-corruption framework. The pattern he was outlining would continue to expand as the hearing progressed. By the time the discussion of the Public Integrity Section concluded, the outline of a larger pattern had begun to take shape. Neguse had established tension between public rhetoric and hiring decisions, then between institutional origin and present staffing reality. The next step in his questioning extended that pattern into another domain where enforcement capacity intersects directly with presidential financial interest. He turned his attention to a unit that had operated with increasing relevance in recent years: the National Cryptocurrency Enforcement Team. The pivot was neither abrupt nor theatrical. It followed the same disciplined logic that had guided the earlier exchanges. Attorney General Bondi, Neguse said, how many people currently work for the National Cryptocurrency Enforcement Team within the Criminal Division? The question was specific and administrative. It did not accuse the department of wrongdoing. It did not allege misconduct by any named official. It sought a number. Bondi did not provide one. Instead, she attempted to redirect the exchange back to the earlier discussion of PIN, signaling a preference to revisit themes she had already framed in her own terms. Neguse declined to shift backward. "I've asked you a question," he replied, reiterating the inquiry about staffing levels within the Cryptocurrency Enforcement Unit. The repetition was not stylistic. It was procedural, an effort to keep the focus on the specific information requested. The National Cryptocurrency Enforcement Team had been established to address financial crimes involving digital assets, an area of law enforcement that has grown increasingly complex and economically significant. Cryptocurrency markets involve billions of dollars in transactions, cross-border exchanges, and evolving mechanisms for concealment or fraud. The team's purpose was to centralize expertise in tracing illicit digital transactions, coordinating with prosecutors nationwide, and ensuring that emerging financial instruments did not become havens for criminal activity. Its mandate reflected the department's acknowledgement that financial oversight must adapt to technological change. Neguse's question remained unanswered. Bondi's response continued to circle back to broader claims about reform and the correction of prior practices. The refusal to provide a straightforward staffing figure introduced a new dimension to the hearing. Earlier, the contraction of PIN had been confirmed numerically. Here, the absence of a number itself became part of the record. Neguse then shifted from inquiry to disclosure. "You know what the answer is," he stated calmly, "and I believe I understand why you don't want to provide it." He explained that the National Cryptocurrency Enforcement Team had been eliminated the previous year. In practical terms, the staffing level was 0. The significance of that revelation did not lie solely in bureaucratic restructuring. At the same time that the Cryptocurrency Enforcement Unit was dissolved, President Trump reportedly held approximately $1.4 billion in cryptocurrency assets. Neguse introduced that figure not as speculation but as financial disclosure. The convergence of those two facts, dissolution of the enforcement team and substantial presidential cryptocurrency holdings, created an appearance of conflict that warranted examination. Oversight exists precisely to evaluate such intersections. Bondi did not dispute the elimination of the team. She framed the department's restructuring as part of a broader strategy to eliminate perceived redundancies and realign priorities. Yet the timing and context carried weight. Cryptocurrency markets present unique challenges for law enforcement, including fraud, money laundering, and regulatory evasion. A dedicated team centralizes expertise necessary to navigate those challenges. Neguse's argument did not hinge on proving direct interference in a specific investigation. It hinged on capacity and optics. When the President of the United States maintains substantial financial interests in cryptocurrency markets, the existence of a specialized enforcement team provides reassurance that oversight remains robust and insulated from political influence. Eliminating that team removes a layer of specialized scrutiny at precisely the moment when financial exposure is significant. The optics alone demand careful explanation. The figure, $1.4 billion in cryptocurrency holdings, was not introduced for shock value. It contextualized the enforcement decision. Financial conflict of interest concerns are not limited to explicit illegality. They encompass structural safeguards that prevent the appearance of favoritism or neglect. A president with substantial digital asset holdings benefits from a regulatory environment perceived as stable and unthreatening. An enforcement team dedicated to investigating cryptocurrency-related crime could, at least in theory, influence that environment. Bondi's refusal to provide a staffing number before Neguse disclosed the elimination underscored the sensitivity of the issue. Had the team merely been downsized or reorganized, A numeric answer would have sufficed. The absence of personnel, however, represented a qualitative shift. 0 is not a reduction, it is a cessation. An enforcement mechanism cannot function without staff. The elimination of the National Cryptocurrency Enforcement Team, when considered alongside the contraction of the Public Integrity Section, reinforced the broader narrative Neguse was constructing. 2 units with oversight mandates, one focused on public corruption, the other on emerging financial crime, had experienced dramatic reduction or elimination. Each decision could be defended independently as managerial reform. Viewed together, they suggested a narrowing of enforcement capacity in areas touching on official conduct and financial oversight. Neguse articulated his concern in institutional terms. When a member of Congress asks how many people work on a specialized enforcement team and the Attorney General declines to answer, he observed, it raises legitimate questions about transparency. The refusal to provide basic operational data complicates oversight's function. Congress does not require classified details to assess staffing levels. It requires numerical clarity. Transparency about structure is foundational to accountability. The hearing room remained composed, but the stakes had expanded. The Department of Justice is entrusted with safeguarding the integrity of financial markets as well as prosecuting corruption. Digital assets represent a frontier of financial activity where regulatory and criminal enforcement frameworks continue to evolve. Removing a centralized enforcement team from that landscape changes the department's posture toward those risks. Neguse's questioning made that change visible. Bondi defended the administration's broader agenda, emphasizing efficiency and recalibration. Neguse's framework, however, examined alignment between policy decisions and potential financial interest. The president's reported cryptocurrency holdings were substantial enough to merit scrutiny regarding regulatory posture. In such circumstances, preserving visible and specialized enforcement capacity can reinforce public confidence. Elimination of that capacity invites skepticism. The pattern that emerged across the hearing was not built on dramatic accusation, but on structural observation. An individual indicted for interfering with police was hired after a pardon. The Public Integrity Section saw staffing reduced from 35 attorneys to 2. The National Cryptocurrency Enforcement Team ceased to exist. Each element involved different subject matter, yet each touched on accountability. Neguse's line of inquiry suggested that oversight must examine cumulative effect rather than isolated decisions. Institutions do not erode solely through singular acts. They shift through a series of reallocations and eliminations that alter functional capacity. When enforcement units are reduced or dissolved, the scope of scrutiny narrows accordingly. That narrowing can influence both deterrence and public perception. Congress's role is to evaluate whether such changes serve the public interest. By the end of this segment, the committee had moved from examining contradiction in hiring to evaluating structural withdrawal in financial enforcement. The questions were not speculative. They were grounded in documented staffing changes and disclosed financial interests. Bondi's responses emphasized narrative framing, but the structural facts remained intact. 0 personnel assigned to a specialized cryptocurrency enforcement team. 2 attorneys assigned to the Public Integrity Section. The implications extended beyond partisan debate. They touched on the durability of institutional safeguards designed to prevent corruption and financial misconduct. Neguse had not alleged direct illegality. He had highlighted alignment between enforcement contraction and areas of presidential financial exposure. That alignment warranted scrutiny under any administration. The hearing's trajectory continued to move from slogan to structure, from rhetoric to institutional design. By the time Neguse concluded his examination of the Cryptocurrency Enforcement Unit, the hearing no longer revolved around a single personnel decision or a single staffing chart. What had emerged instead was a composite picture of contraction, where the mechanisms designed to scrutinize power appeared to be receding at the same time executive authority projected rhetorical strength. The pattern was not assembled through insinuation, but through record. A pardoned January 6th defendant hired into federal service, a public integrity section reduced from 35 attorneys to 2, and a national cryptocurrency enforcement team dissolved entirely. Each data point stood on its own. Together, they traced a trajectory. Neguse addressed the chairman directly at one point, not in protest, but in recognition of the hearing's deteriorating clarity. "I think what is happening at the Department of Justice is a disgrace," he stated, urging the chair to maintain order. That remark did not represent theatrical escalation. It reflected frustration that basic administrative questions had required repeated prompting. Congressional oversight depends on the willingness of executive officials to answer operational inquiries in good faith. When those inquiries are met with redirection or refusal, the friction becomes institutional rather than personal. The record at that stage contained no speculation. It contained Bondi's confirmation that Jared Weiss worked at the Department of Justice after receiving a presidential pardon for conduct involving interference with law enforcement on January 6th. It contained verified staffing numbers for the public integrity section, reflecting a reduction of 94% under her tenure. It contained acknowledgement that the National Cryptocurrency Enforcement Team no longer operated, even as the president maintained substantial cryptocurrency holdings. Each element intersected with the broader theme of accountability. Neguse framed the cumulative effect carefully. "The questions I've asked are not trick questions," he said. "They are basic questions about how the department functions." He emphasized that oversight does not hinge on dramatic revelations, but on transparency about structure and capacity. An attorney general unwilling or unable to provide such transparency complicates Congress's constitutional role. The broader implications extended beyond the hearing room. The Department of Justice commands unique authority to investigate and prosecute misconduct at every level of government. That authority draws legitimacy from the perception that it operates impartially and consistently. When enforcement units contract significantly or disappear, the scope of potential scrutiny narrows correspondingly. Deterrence depends not only on statutory authority, but on visible capacity. The hiring of a pardoned individual indicted for interfering with police intersected with the administration's public commitment to defending law enforcement. The reduction of PN intersected with the historical lesson of Watergate, when institutional safeguards were strengthened to prevent executive abuse. The elimination of the Cryptocurrency Enforcement Unit intersected with substantial presidential financial exposure in digital assets. None of these developments alone constitutes proof of corruption. Collectively, they reshape the landscape in which accountability operates. Bondi consistently defended her reforms as corrective, portraying them as efforts to eliminate prior politicization and restore fairness. Neguse's questioning illuminated a different dimension, whether corrective action had crossed into contraction that diminishes enforcement capability. Institutional balance requires calibration, not dismantling. The record did not demonstrate that corruption had occurred. It demonstrated that the mechanisms designed to detect corruption had been weakened. Oversight hearings often conclude without dramatic resolution. There was no sudden admission or concession that altered the trajectory of the department. What remained was the documented record, video footage, indictments, pardons, staffing figures, and the absence of personnel in a specialized enforcement unit. Congress's role is to create that record and allow the public to evaluate its meaning. Neguse had fulfilled that role through structured inquiry. The phrase that opened the hearing, "If you come for law enforcement, the Trump administration will come for you," returned in sharper relief by its end. The administration had extended employment to a pardoned January 6th defendant whose conduct involved confrontation with police officers. The public integrity section created after Watergate operated with 2 attorneys. The National Cryptocurrency Enforcement Team no longer existed. Each fact complicated the simplicity of the initial declaration. Accountability in a constitutional republic depends on more than assertion. It requires institutional muscle, transparent staffing, and a willingness to submit decisions to scrutiny. When enforcement units are reduced or dissolved, the public must assess whether efficiency or insulation from scrutiny is being prioritized. The Constitution anticipates tension between branches precisely because such evaluation cannot be left to executive discretion alone. Congress's oversight power exists to ensure that executive authority remains subject to inquiry. Neguse's method never abandoned that framework. He did not rely on hyperbole or insinuation. He relied on sequential logic. Establish the public statement, present the documented conduct, confirm the hiring, examine the staffing of anti-corruption units, and reveal the elimination of financial enforcement capacity. The progression from individual case to institutional structure clarified the stakes. The Department of Justice does not merely prosecute crime, it symbolizes the rule of law. When public confidence in that symbol erodes, institutional legitimacy suffers. Watergate demonstrated that unchecked executive authority can corrode trust in government. The creation of PIN signaled a commitment to structural safeguards. Reducing that section to minimal staffing alters the practical reach of that commitment. Eliminating a specialized financial enforcement team alters the department's posture toward emerging economic risk. Bondi's testimony did not concede wrongdoing. It did, however, confirm the structural changes identified by Neguse. Oversight does not require confession to be effective. It requires clarity. The hearing produced clarity regarding staffing levels and enforcement priorities. The public record now reflects those realities. In the end, the hearing did not resolve whether the department's reforms constituted prudent recalibration or troubling contraction. That determination extends beyond a single session of questioning. What the hearing accomplished was to illuminate the alignment between rhetoric and structure, between declared principle and administrative action. Neguse's inquiry placed those elements side by side without embellishment. The juxtaposition will persist in the congressional record long after the microphones are turned off. Pam Bondi's online declaration promised unequivocal defense of law enforcement. The department under her leadership employed a pardoned January 6th defendant, whose indictment involved interference with police officers. The office created after Watergate to investigate corruption now operated with 2 attorneys. The specialized team dedicated to cryptocurrency enforcement no longer existed while the president maintained substantial digital asset holdings. These facts are not narrative devices. They are administrative realities. In constitutional governance, administrative realities matter more than slogans. The strength of an institution is measured not by the force of its declarations, but by the resilience of its oversight mechanisms. When those mechanisms contract, questions inevitably follow. Congress's responsibility is to ask those questions. On February 11, 2026, Joe Neguse did precisely that, and the answers, along with the silences, now stand recorded.